Bismillah ar-Rahman ar-Rahim. Welcome back. We're on to our final interview of the morning. It is 9:53 a.m. and we are honored to be speaking with former acting judge of the South African High Court and also a pioneer of Islamic Banking in South Africa, and that is Senior Counsel, Advocate A.B. Mahomed. I hope I've introduced that in the right order. Assalamu alaikum to you. Welcome to the program. And on the show this morning, we're going to ask you to talk to us about the history behind the first ever South African Muslim marriage certificate, and undoubtedly a huge win for the Al Jamaa party. Wonderful to have you here. Welcome.
Assalamu alaikum wa rahmatullahi wa barakatuh. I think the recent confirmation of nikah certificates by the minister has concluded a journey that started some 158 years ago.
Sure.
The genesis of this was really a judgment of the Privy Council in London going back 1866. It's called Hyde versus Hyde. In that judgment, a Christian missionary who converted to Mormonism sought a divorce, and then the matter came before the Privy Council, and Lord Penzance, who defined monogamous marriage from a Christian perspective, that it is the life union of one person to a spouse to the exclusion of others. And that was the Christian notion of a monogamous marriage. And that became a landmark judgment in the British colonies. It's affected many other countries that were under British rule, as you know, the British Raj. And interestingly, 3 years later, 1869, there was another judgment of the Nawab of Bhopal. Nawab of Bhopal had married an English woman, and she in turn, of course, it was a second wife. The Nawab had married his cousin as the first wife. Although she lived in a palace, she was quite unhappy to be wife number two. So she went back to England and she instituted divorce proceedings. It's called the Nawab of Bhopal versus Wahiduddin. And in that case, the Privy Council applied the same thing because it was intercultural, interreligious marriage. But they said that since Islamic marriages are potentially polygamous, therefore it is contra bonos mores, meaning contrary to the good policy of monogamous unions of the Christian faith. And that in turn led to the migration of this judgment to South Africa. If you recall, historically, 1860, Indian immigrants came to South Africa, particularly to the Natal colony, as indentured laborers. And then in 1872 was the first batch of Muslim traders who came in as what was then described as free passenger Indians. Now, there was some legislation where you could register your marriage, but by 1885, Muslims owned something like 20 properties in Durban. And what happened was Islamophobia emerged.
Sure.
You found that the Pietermaritzburg Chamber of Commerce of English-speaking settlers filed a complaint to Queen Victoria that we were expecting laborers, but not business people. And this in turn led to the commission, it's called the Thomas Walter Ragg, Justice Ragg Commission of Inquiry in 1885. This inquiry is a 600-page document, and Justice Ragg concluded by saying that the Muslim businesses were referred to as Arab traders. And it is very interesting to note what the judgment said, or the judge. He said that they, meaning the complainants, the English speaking settlers, are quite happy to have them, meaning the so called Arab traders, as their laborers, but not as their equals. And the second finding of the learned judge was that the economic exploitation of Natal shall be exclusive for the European. Now, you couldn't be more blatant and brazen than this, that this was the colonial mindset. And the English speaking settlers of Natal took this judgment as a cue so that if they could argue for the non recognition of Muslim and Hindu marriages, the effect of that would be that the Muslims and Hindus would find it very difficult to live in this country knowing that their marriages are not recognized and their children will be deemed illegitimate. So, this was the first introduction of what I would say institutional apartheid, which was non recognition of Muslim and Hindu marriages. If you recall, this was in 1887, the judgment, by which time we already had, I would say by 1880, gold discovery. 1860 was the diamond discovery. There was a need for the non-white or Europe, at least for the black population, the indigenous population, to offer their labor in the market. So the legislation that started against the indigenous people, against Muslims, against the population of the Cape, it started accelerating that process. But the first struggle for, let's say, the anti-apartheid struggle was really the recognition of Muslim marriages and Hindu marriages. Mohandas Gandhi was given this task, and he didn't succeed entirely because the Indian Relief Act of 1914 led to the similar pattern that emerged in the Cape. I think it was a reference to 1881, the Cape Colony Marriage Act, that marriages would only be recognized if they are registered. So we had the struggle that continued. And in 1917, there was this famous case of Sidat executives versus the masters, where the appellate division applied the same reasoning as the Bhopal case, as well as the Hyde versus Hyde case, that Muslim marriages are contrary to public policy. And that was an appellate division judgment. So the procedure went on because that was the final say. We had many, many cases, dozens of them between that period up to the period of the, let's call it the transition or the emergence of the new dispensation. But there was occasionally incremental improvements, but not to the extent of a full formal recognition of Muslim and Hindu marriages. I'd like to
Okay.
fast forward.
Can
Yeah,
All right. Can I
sorry.
just come in here and make a comment and possibly a question to you as well? And I just find this so fascinating. And this is a piece of our history that we should know about. How come we don't know about this? I think it's very, very fascinating. Um, Question number one. In the time of Sarchi Bartman, she, I think, was married to a Muslim. Either she was married to a Muslim, but I do know she bequeathed a piece of land in the Western Cape to the Muslim community to build a mosque, etc. Was she, in fact, if memory serves me correctly, was she married to a Muslim man, or did she just revert to the religion and decided to bequeath this land? That's my first question. And in this current age and day, with the recognition of the Nikah certificate, how is this going to accommodate polygynous marriages in our community. So I'd like you to pick up on where you left off regarding the history, but I'd also like you eventually to respond to these questions if you don't mind.
Okay. I think if we fast forward to 1979, now I was personally involved in that that year, 78, 79, as a practicing advocate. I had been a part-time lecturer for final year law students on Islamic law. And in 1979, I received a call from a Mr. Waits from the Human Science Research Council. He made an appointment and came to see me in Durban in my chambers. He said that he had an assignment given to him by the Human Science Research Council because of a particular problem they faced. And that was that in Natal, I think in Durban, there was a case where a Muslim was charged with fraud. And the prosecutor had subpoenaed his wife to give evidence against him. Now, it's universally recognized that a wife cannot be compelled to give evidence against her husband. Now, the prosecutor successfully argued before the magistrate that the wife, because Muslim marriages are not recognized,
Wow.
the wife is strictly not a wife.
Sure.
And this technical argument was accepted by the magistrate. And then she gave evidence, and eventually the accused, that is, her husband, was convicted. The matter, as you know, it's when you are sentenced to more than 4 months imprisonment, the matter comes before two judges on automatic review. So this matter came before two judges, and although we would say that they were part of the apartheid system, however, they found it unconscionable that though the magistrate was technically correct in applying strictly the law, not the spirit of the law, but just the wording, there was a sense of injustice. And therefore, when they signed, usually the judges on review would sign that this matter accords substantially with justice. In this case, they made an endorsement that this matter should be investigated by the Human Science Research Council.
Wow.
They, of course, reduced the sentence. So this is how the matter came before them, and Mr. Waits was given the task now to inquire into Muslim marriages. What is it? Does it involve customs, rituals, etc.? And there we sat in chambers and we had a 3 hour discussion where I explained to him that Muslim marriages were positive law, offer and acceptance to be witnessed, etc., the usual standard requirements, and that this has been a very enriching process over 14 centuries. So he then said to me, would you prepare for us as the scope and application of Muslim personal law in South Africa? And they would give me the references, etc. I accepted that responsibility because I know how important this was for the injustices that had been committed against our women for the last 100 years. So they sent me a reference, which I still have, and for the next 9 or 10 months, I prepared a 250-page document, which is titled The Scope and Application of Muslim Personal Law in South Africa. The brief sketch of that document was that we need to set up a special court, something similar like the tax court, when you have an issue, particularly relating to a particular component, that you have your judges, but the judge is assisted by two qualified assessors who would be experts in Islamic law. And then, of course, there were a host of other suggestions, such relating to consent, relating to matters of property rights, etc. And this document was signed and presented in 1980 to the Human Science Research Council. Now, what happened during that period, if you recall, we had the Soweto riots of 1976. We had a global situation, the collapse of the Soviet Union in 1979 or 1980. You had, of course, the Islamic Revolution in 1979, and, of course, the Cuban crisis. All of these put together, and of course, the anti-apartheid movement was gaining grounds. We had the arms embargo, and you had, of course, the sanctions against South Africa. So this type of geopolitical events led to the UDF being established in 1983, and of course the tricameral parliament in 1984, of course 85. This document somehow reached the tricameral parliament. And when it did, it was debated and discussed. I do not think in depth, because the Hansard report suggested that this matter should be referred to the South African Law Commission, which is different from the Human Science Research Council. So when it came to the Law Commission, in terms of the Commission's Act, what happened is the matter was published. And when it was published, inviting comments, we had different components from the ulama bodies, various other bodies, and they in turn were suggesting differences from all the madhabs, from the, let's call it the Shafi madhab, the Hanafi madhab, etc. I get a call from the Law Commission to say, what is all this? I mean, they were getting confused now because it was a simple process of strictly confining to the law and to some extent distancing cultural sensitivities. So the effect of that was that the matter was referred to, I think it was the the Raan Afrikaans University, who communicated to me. I felt somewhat disappointed that there was some kind of resistance from our own communities to what would have progressed faster, and for some highly irrational arguments. And however, this matter stayed for a while, for that period between 1985 to 1990. During that period, we saw the UDF struggle. I was also then the president of the Islamic Council of South Africa, and we had made a public statement that there was a strong objection to the tricameral parliament. So there was an issue that this matter would somehow or the other be politicized. It would take some time, and it just stayed not necessarily stillborn, but just gathering some dust until 1990, when it was once again resurrected. After the CODESA period, the successful transition between the apartheid system and subsequently the non-racist democratic dispensation. So the matter came up. But you could see at that point in time the convergence of three legal systems. One was Islamic law, the other one was the positive law of Roman Dutch law, Germanic law, the English Code, common law, English mercantile law of the 3 centuries that eventually merge into a hybrid version of distinct South African law, and then, of course, CODESA and the discussion for constitutional law. So in between, right at the center of the convergence between these 3 legal systems, Muslim personal law document was sitting pretty there, and somehow or the other, and very intensive debate discussed and started. I don't know whether it is Project 59 or 53. I'm just going from memory, but that was the project of the South African Law Commission. So, of course, the ANC also took this matter up. From a political point of view, there were some incremental developments during the interim constitution, but the greatest degree of resistance was from ourselves, the Muslim community,
And why is
and
that?
highly irrational. It's simply because of I would say, politicizing what was necessary for justice for women and children. And during that period, I recall even the Justice Department saying they were fed up. They were saying, why are Muslims resisting this? And for the dangers of simply ignoring it, it took some time because various, they would say, factions. Now, I think the argument was basically threefold. One was that there was this gender issue, which was an argument presented by some of the groups. The other one was that Muslim law might subordinate what was already the constitutional law and the Bill of Rights. So that was a legitimate argument to deal with, not that it was superficial. And the third one was, we could say, what they call it, entanglement, meaning that the judges would be inclined or least inclined to come into religious arguments. Now, all of these 3 points were being bandied about from pillar to post, from one department to the other, huge costs that, in my view, totally unnecessary, and eventually reached the Western Cape High Court and finally the Constitutional Court. So the journey of 158 years, I would say that whilst it was imposed by the colonial powers, the last 40 years, in my respectful view, was totally unnecessary. If the communities and the organizations simply sat down and looked at it rationally, we would have had Nikah certificates 40 years ago.
Sure. Okay, we're
Anyway,
going
it,
to,
it
sorry about that. We're going to have to wrap up in a short while. Um, you must be very pleased with the outcome eventually because a lot of your hard work went into the formation of the current NICA certificate. And if you can still manage to comment on the two issues, the main one being how does polygynous marriages in this day and age, now that we have the NICA certificates, how is that going to feature? Is it going to is it going to be seamless? Is it going to create complications, or has there been accommodation in the current system for polygynous marriages, Muslim marriages?
yes, I haven't recently familiarized myself with the point that you raised, but I recall in the submissions I had made on behalf of the Society of Advocates of KwaZulu Natal some 10 years ago, that this issue was discussed and that would be brought to the attention of the relevant parties. But I think the main principle we should keep in mind is in Islamic law, monogamy is the rule, polygamy is the remedy, and that is the essential principle. So there are mechanisms to discuss this question, and this would apply to a similar situation like customary law that applies to the ethnic populations, such like. I do not see any problems now that we have traversed this difficult road for so many decades. The other point I wish to make, and I would like to commend our current Deputy Minister of Social Development, Hanif Hendricks, Honorable Hanif Hendricks of the Al Jama party, in that whilst it was in the milieu between that difficult period, he stuff. Between 1990 and recently to 2023 or 2022, he was, as the leader of the Jamaa party, in regular communication to me from time to time and pressing for the recognition. And many of these departments were quite frustrated about the kind of resistance that was coming, not from the other communities, but from our own communities. So it's commendable that what he did, much of this, I would say, recognition and appreciation must be given to him.
Thank you indeed. Unfortunately, we have run out of time, but I'm hoping that you and I can have some more such in-depth discussions. You've just shared with me and all of our listeners a very fascinating piece of history with me, and I truly, truly enjoyed listening to you sharing that with us. I think the Sarchi Bartman issue we will leave, hopefully for another time. But thank you so very
Yes,
much
most.
for all of the hard work, dedication, and love you've put into this work, which is obviously going to ease our lives going forward. Shukran, stay well, keep us in your du'as, and assalamu alaikum to you.
Shukran. Assalamu alaikum to the viewers and once again to you as well. Thank you.
Advocate
Khuda Hafiz.
A.B. Mahomed, Senior Counsel, and of course also an acting judge at some point in his life. I was so very fascinated by that discussion. I can't wait to have future in-depth discussions with this amazing man, inshallah. Time for me to wrap up. Thank you indeed for your company on the show this morning. Till tomorrow morning at the same time as always. Assalamu alaikum and Khuda Hafiz. From me, Julie Ali.
We are here in the middle of a Zahra neighborhood. The whole neighborhood is already destroyed. More than 17 towers are down. Here, as you can see, the firefighters trying their best to help. The people are still under the rubble. A lot of the people.
Join Hamza on his exclusive South African tour as he shares his personal experiences, never before seen footage, and powerful insights on the ongoing genocide in Gaza. This is more than just a talk. It's an invitation to witness Gaza through the lens of Hamza Sha'alan. Don't miss this opportunity to meet the photojournalist who brought Gaza's pain and perseverance to the world in its darkest moments. Follow Salam Media on social media pages for more on this tour and be part of a